Thank you, Marinette, and welcome, welcome back, everybody. I do have a little, echo there, so we may have to get Andrea and Donna to mute for us. I want to welcome back Donna Berger from the Becker Law Firm to episode 4 of our COVID-19 webinar series.
Hi, James. Happy to be back.
Yeah, welcome back, Donna. And we have with us a special guest, Andrea Northrup from Insurance Office of America. And I'm going to do a more proper introduction in a minute. Just a reminder on, welcome, Andrea. Sorry I didn't get you a chance to say hi. Just a reminder on format. We have a really exciting, interesting topic today on liability and risk mitigation in the world of COVID-19. So we're going to kind of jump into the substance of that with some pre-questions that we've discussed. But at any point, you can Q&A, and you're welcome to, and we will get to those, some of them as we go along if they're relevant, and some of them near the end. And some of those questions may not be about today's topic, and that's fine. If we have time at the end, we will answer some of those. I also want to mention that you were kind enough to send, sorry, I'm getting a message from my team here. We are getting an echo. Andrea and Don, if you can mute while talking, and I'll do the same. Okay. Thank you. We got so many great questions from you, and I don't want anyone to think we're not seeing them, but we literally got 300 questions. So what we've tried to do is, number one, narrow them into today's topic, and two, it really helps us shape future episodes. So please keep them coming, and I apologize, you may not get your question answered, but it's really just a case of volume, and if we get enough of the same question, we'll bring it up. So with that, last week, I just wanted to give you a quick update. We addressed association finances, violations, and enforcement. And Donna reminded me of a statement I made last week I wanted to clarify. I had said that the Families First Act did not apply to associations. I meant castle associations, associations with less than 500 employees, it does. So I think that was the one clarification that we wanted from last week. And then last week, we also talked about the CARES Act and collections. And just anecdotally, our advice last week was collections as normal. And I can now give you some data points, especially I have a lot of Castle clients on the phone. We compared our collections, our accounts receivable from the same date in 19 and 20, and the same date from April this year to January this year, which are quarter starts, and we have no material change. So our owners are, for the most part, and there may be some exceptions on the phone, paying their maintenance. And I think that's because there are forbearance allowances by state and federal government for mortgages and for rent, but not for association dues. And I think also our owners know that we can't pay the bills if they don't pay their maintenance. So I'm very happy to report that I think that recommendation has been well received by not only our associations, but our owners who are paying their maintenance. So that's very, very good news. By the way, if you want to catch up in any of our past episodes, they are on castlegroup.com, and a lot of the questions you've asked in your emails are answered on those past videos. And in addition to the chat today, you can at any time email, even between episodes, info@castlegroup.com if you have a question you want to get answered. With respect to sometimes we'll get a couple of people who get logged off for whatever reason, we don't know. But my only advice to you as the technical guy that I am is log off and log back on, and you should be good to go after that. And then my final comment before we get going on today's agenda is, obviously Donna is with Becker and is an attorney, and Andrea is with Insurance Office of America and as an insurance expert. But really, we're having a conversation, and I don't want anyone to interpret any of our conversation as advice, legal or otherwise, to you specifically, because we don't know your circumstances. Anything that you find may be appropriate to your community, please go ask your own attorney and your own insurance person and your own management company if it's not Castle. But with that, I'd like to tell you about what we have today and why, and try not to scare you. Whenever you have events like this, whether it's a hurricane or other natural disaster, there's potential for lawsuits, especially after the fact. And when you do have these after the facts, you always look back and go, what could I have done today to help mitigate what could potentially be a risk? So we're going to talk today about what some of those potential risks are, how to mitigate them with management practices, and then how to mitigate them with insurance. And what I'll tell you, just because I know we have a lot of board members, this is it's really an informational, and the chances of this impacting in a material way, especially personally as a board member, is very remote. There's all kinds of rules and regulations that Don is going to tell us about that protect board members. So please don't let any of the conversations scare you. It's just an awareness that we're trying to create today. So with that quick update, I think the trends are improving in Florida. And by the way, we did a separate Texas seminar, so I'm going to keep my comments to Florida today. When we first came on, it went from 2,400 cases in Florida to 8,000, which was a tripling. And then last week it was to 16,000, which was a doubling. And this week it's 21,000, which is a 50% increase. So the rate of increase is plateauing, and that is what we've been looking for. So that's a good thing. So that's our trending, and I think as long as we keep social distancing, we will be to the recovery stage, which we may address a couple of those questions at the end. So with that, Andrea, just give us a little background. We haven't met you on this webinar series. Tell us a bit about yourself, and then we'll jump into some questions.
Absolutely. Well, thank you very much for having me. Thank you, Castle Group and Donna. Pleasure to be serving with you as a panelist. I've actually been with Insurance Office of America for a little over 12 years. And prior to that, I was a practicing attorney. And so coming over and doing the risk management insurance gave me the opportunity to take my knowledge of risk management and liability and contracts and put it into play before the claim happens to help educate people. And so I really look forward to contributing to today's seminar.
Excellent. So, Donna, let's start with you. What would be kind of the nature of items we should be looking at, and maybe just do kind of a summary, and then grab a couple of them and break them down and really get somewhat granular on what we should be doing from management, legal, and insurance to mitigate risk for the associations and our board members. Donna.
Yeah, as we head into this next phase, James, as we've been talking over the last 3 episodes about the protocols that boards have hopefully all now put into place and about enforcing those protocols. We've also talked about continuing with our collection policies to ensure that we can continue to fund essential services. Now we're kind of looking ahead, down the road, so to speak. Boards have a general duty to maintain the common elements in a safe and reasonable condition. The association does not typically have a general duty to protect against actions that third parties may take, with the exception that if there is a foreseeability of risk and the association has the ability to do something about that risk, then they do have a duty of due care and a duty to act. And we certainly know that there is a risk of transmission of the COVID-19 virus in our communities, because we know now, pursuant to what the CDC and the Department of Health and other medical and emergency professionals are telling us about how this virus spreads. So boards do have a foreseeable risk that they're facing. We do know how it's transmitted, and nobody here is going to provide any sort of medical advice, but we're talking about how might boards potentially be impacted in terms of litigation. It's either going to be as a result of actions they took or actions they failed to take. So you really, either way, you're going to get criticized. Whether litigation results or not, we know this, that there will be some criticism. There will be criticism that you close down the pool and the pool deck and all the common areas, and people are homebound. And what do they want to do? If they're homebound, they want to use those areas. But you're going to also have criticism if you don't close those areas down. So we're going to be looking at the actions that boards took and perhaps the actions that they didn't take. But the good news you alluded to, James, at the outset is that the courts have given boards very wide deference when it comes to the decisions they make. This is called the business judgment rule. And unless the boards are acting in an egregious manner, in an arbitrary or capricious manner, the decisions they make, if they're reasonable and they're exercising due care, the courts are typically going to give them wide latitude in terms of those decisions. And as a matter of fact, our shared ownership statutes and the not-for-profit statutes actually incorporate the business judgment rule into those statutes. So that's the good news. If you're sitting on the board, be reasonable, don't be arbitrary, don't be capricious, reach out to legal counsel and craft the protocols that make sense in accordance with what the medical professionals and the legal advisors and your management are telling you to do in terms of safeguarding your community. And I know Andrea is going to talk about the fact that even though there's deference that the courts give in terms of business judgment rule, there's still the issue is their coverage.
Donna, the business judgment rule is a really a good one, and I think we're going to have some questions on that. But I want to give an example. I know we're going to come back to it. If all governmental authorities say you should close your pool and you don't, that would probably put you beyond good business judgment because, you know, we're operating under a mandate. And I'm not looking for you to respond to that one right now, but there's an example that I hear a lot of. I hear a board saying, well, we're not going to follow that rule. I'm like, that could put you outside the business judgment rule. And before I go to Andrea, the other, I think, important mitigating fact, or in most associations, for personal liability of its board members, because I know that's a concern, is the indemnification provisions in most documents. Donna, can you talk to that, please?
She's going to spend some time talking about coverage, and it might be a little scary when she mentions the words exclusions, but in every set of association documents, every set of documents I've seen in the past 25 years, I'm dating myself a little bit, there's an indemnification provision. If there wasn't an indemnification, we'd be hard-pressed to find volunteers to serve on these boards to start with. So there is language in your documents, and I'm sure everybody listening is going to rush and look at their articles and the bylaws just to check it's there. But there is language which typically says that directors will be indemnified should they be sued for actions they take while serving on the board. So that should provide another level of comfort that if you're doing the right things and you just happen, listen, we live in a very litigious society. We know that. We know that there are likely down the road to be people looking to perhaps pursue some claims. The good news here today is we're still in the midst of this. So if you've taken maybe a more lax approach up until this point, the takeaway from today is reach out and start mapping out the correct COVID-19 protocols. It's not too late to do that. It's not too late to safeguard yourself from any potential liability.
Thank you very much for that. I really want to make sure our board members listening take some comfort from the kind of structural protections there are for them. With that, Andrea, I'd like to turn to you and maybe just in the beginning, describe to us a typical association and what types of policies they should have and could have, and what are the types of perils that they cover. Andrea. You're on mute, Andrea.
All right, how about now?
Yeah.
You're good? Okay, perfect. So for the typical association, you're going to have probably 7 or 8 different policies that are going to be in line. The ones we're going to address primarily today are going to be directors and officers policies and your general liability policies. It may trigger your umbrella policy. And then there's a 4th policy that you may or may not have with regards to some additional defense. And so your directors and officers policy is going to be the primary policy that is going to respond in the event that you have a claim that's going to be related to, you know, violation of the statute, enforcement of the governing documents, the bylaws, you know, a DBR claim, something of that nature. And that's really where we anticipate a lot of these claims that are going to be coming in with regards to decisions that the board is making to either safeguard or fail to safeguard the association. The general liability policy is a third-party protection policy primarily for bodily injury or property damage that is the result of alleged negligence on behalf of the association. So those are usually going to be your slip and falls. But in this particular case, it could be an allegation of picking up the COVID illness at a facility that's owned by the association for their negligence. And then you have those two should be underlying policies to your umbrella policy, which should just increase your limits for you. And then finally, what you have possibly have is a legal defense policy as well. And the highlight to that is that it can offer defense, but it's important to understand that it doesn't offer loss or judgment or settlement protection. And there's some key differences even in your underlying directors and officers policies where you might have coverage for something, but you have defense only coverage and you don't have loss coverage. So those are going to be the primary policies we're addressing today.
Andrea, you were garbled for the first part. We got the, no, you came back, so it was probably just an internet connection. I know you're at home. Could you, we got the legal defense clearly, but you were garbled at the beginning on your general liability. Would you mind just repeating the general liability, the nature of that policy?
Not a problem. So the general liability policy is the policy that's going to respond to defense for the association in the event that their alleged negligence resulted in property damage or bodily injury of a third party. So that's normally what we think of for our slip and falls, but that's also going to be the policy that could be triggered in the event that somebody alleges that it was the negligence of the association in sanitizing the common area facilities and they contracted the COVID illness.
Did you mention, just because you were garbled, I want to make sure, what about umbrella policies?
Absolutely.
For associations?
Correct. So your umbrella policy should be a follow form policy. And what that means is it's going to serve to increase the limits of an underlying scheduled policy. So it should go over your directors and officers policy. It should go over your general liability policy. So if your underlying policy has $1 million limit, if you have a significant enough claim and it pierces that $1 million limit, then you have the benefit of the umbrella policy that's going to go, maybe it's a 5 million, 10 million, it could be $100 million policy that could trigger. At the end of the day, what's most important is understanding how the forms from the underlying policies transfer to the coverage afforded by the umbrella policy.
I think that's really important. There's, I see you, Donna, just a minute. I think follow form is something I've learned that if it isn't covered under your underlying policy, it's not going to be covered under your umbrella policy. I just wanted to make that one point. Donna, you had a comment on that.
Myself. Now I am. Okay. So you're controlling us, James.
This is perfect. I really love it.
I can't unmute myself. I just wanted to follow up on what Andrea said, because we're basically going to be looking at two classes of damages. We're going to be looking at the economic damages due to, let's take lost rent. The association has implemented a no move-in policy for new tenants or new purchasers. And somebody claims that they've lost a sale or they've lost a lease as a result of that policy. There will be quantifiable economic damages from that. We can calculate what the lost rent will be or the lost purchase price, as opposed to the bodily injury, the personal injury or the wrongful death claims that may result if a plaintiff makes the case that the virus is spread in the building or in the community because proper protocols were not implemented. What are the different hurdles in terms of coverage and exclusions if we're looking at economic damages versus bodily injury?
Yeah, Andrea?
Can you hear me?
Yeah, go ahead.
Okay, perfect. So it's really going to depend. It's the nature of the claim that's going to determine which policy it's going to fall under. And so if it's primarily economic in nature related to a board decision that affected them, that's going to be a directors and officers policy. So then in essence, we go to that, which is a contract, and we look through and see what terms we agree to. And I think one of the things that would probably be most difficult for an association is that they may find in a directors and officers policy that they have an exclusion with regards to loss of value or loss of rent or property valuation associated with it. And so while it's something of the nature that would normally fall under that policy, there's a possibility that they're going to have an exclusion, which means there's going to be neither defense nor is there going to be any sort of coverage associated with it. Whereas if you had somebody who said, you failed to abide by the statute in an election, or you didn't go through with the governing documents, where that may not be an exclusion. And you're going to find directors and officers policies in the state of Florida are going to have significant exclusions as they touch upon anything that's going to be COVID related: bodily injury, sickness, emotional distress, mental anguish. Those are pretty clear exclusions in the majority of directors and officers policies in Florida.
Yeah, so I just want to summarize that. So most associations would have a general liability policy, obviously a property policy, a D&O policy. Most would have an umbrella policy. The idea of a legal defense policy is a relatively new thing, and I know hasn't been recommended too much in the past. It may all of a sudden be very popular. So those are the policies, and the whole idea of exclusions is going to be super important here, because when insurances, they love to take your money and they don't like to give it back to you. So exclusions is the tool they use for that. And that's going to segue so nicely in, well, if there is an exclusion, we better do what we think is right and mitigate our liability through management and best practice. So I want to move on, Donna, to a couple examples, but do you have any comments on the kind of the spectrum of policy or exclusions before we jump into a first example?
We didn't touch on the legal defense, which most of our associations don't have. I can tell you from personal experience, we have a smattering that may have that, but we also know that these companies are now sending out flyers and targeting associations and saying, hey, we'll cover COVID-19 claims. I'm sure Andrea will touch on this as well. You need to read the fine print. It only covers your defense costs. It's not going to cover any out-of-pocket settlements. And, it may or may not make sense for your association. So we know associations are going to be on the receiving end of those flyers on a legal defense coverage. Andrea, I'm sure you're going to talk to us about the exclusions there as well. I want to go back to what Andrea said about the types of claims. You're going to have the loss of rent. You may have the bodily injury, but you may have certain types of complaints and claims related to canceling your annual meeting or your election. Those are the types of claims that you can avoid. And I hope we spend some time talking about that today, because to the extent that you should be looking at alternate ways to hold your meetings, to conduct your document inspections, to hold your elections, you should be doing so. While emergency powers allows you to cancel or reschedule meetings, there's no reason if you're not working with management and legal to set up those meetings electronically via Zoom. So there's a number of potential claims out there that we can head off at the pass by just coming up with deliberate protocols. And that includes on the move-ins, James. Some communities are saying no move-ins, but there may be other ways to permit limited move-ins, limited guest entry, while not allowing risk to come in, but still allowing certain transactions to continue.
Okay, you've hit on a couple of points there. I want to reiterate from past shows is really with technology, and we've at info@castlegroup.com, we can give you all the different methods you want. There's no reason not to hold a meeting. And so that's one takeaway from that. So let's jump into a real world example, Donna. We closed our amenities. We either did it too early or too late, or we haven't reopened. I'm sure we're going to get complaints of all three of those. What's the potential liability there, and how do we mitigate it from kind of a management perspective? And then I'm going to ask Andrea what kind of coverage we would have if we got a lawsuit about not being able to access the common areas. Donna.
Well, for the recreational swimmer, I think they'd be hard pressed to come up with any actual damages because the pool is closed. I personally had an association where somebody was prepping for hip replacement surgery and came up with the request that they needed to continue swimming. In that particular instance, we did not grant that request because, again, we had closed the pool and the pool deck. I know early on, James, you and I talked about this. There was a lot of misperception out there that closing the pool somehow had something to do with the water. It didn't. It had to do with the pool deck and congregating on the pool deck. And you really did touch on it. Is this like a Goldilocks situation? Too early, too late? You want to get right in the middle? The bottom line is now we've got county orders, we've got municipal orders that all say the community pools should be closed, but we do have that confusing order from Governor DeSantis that says swimming is an essential activity. So some people are hanging their hat on that language in the governor's order about swimming being an essential activity. However, if you read the order in its totality, it says so long as social distancing can be observed. And in many of our communities, there's just too many residents for them to be able to enforce social distancing on a pool deck without assigning staff members full-time there. And even then, it would be difficult. So in terms of the liability on the closures, you may have people who claim that, you know, you didn't close it. Certainly to your point earlier, James, if you left your pool open with an order that said it should be closed, that could be problematic, but hopefully you've closed it now and you've taken the proper protocols.
Yeah, the couple of points on that. I think as a management recommendation would be, I would be advising my clients to follow the most restrictive order. There is some confusion between state and local, but not only, forget the legal part, the intent of, if, you know, Miami Beach has a more restrictive order than maybe the state, there's an intent there for us as a collective to honor it. Donna? No.
Those people have to understand that those orders are the floor, not the ceiling. So associations are the most local of restrictions. The associations, we've already had confirmation that emergency powers under the statutes have kicked in the midst of this pandemic. So some of our associations are looking at those orders as the ceiling. In fact, they're not. They're the floor. And we see that in ordinary life. Our associations don't look to local ordinance or municipal ordinance in terms of, let's take, for instance, architectural control. They look at that as the floor in terms of what you need to get a permit, but they may have additional restrictions beyond that. And those same rules apply here. If an association feels that they need to take more stringent steps to safeguard their residents, then they should speak with council and figure out how to do that.
Good point. The regulations are the floor, not the ceiling of what they can do. I know we've already got questions coming in, and if they're relevant to what we're talking about right now, I'm going to insert them. Donna, you and I have talked about on multitude times. So I'm just going to kind of more make it a statement. We have questions. Well, if you're closing amenities, why don't you lower maintenance? And the answer is that maintenance is created the result of a budgeting process that estimates expenses for a year, results in a maintenance fee payment, and that money comes in no matter what, unless they need more. It could be a special assessment. By the way, that doesn't mean an association can't redo their budget, but for the most part, that gets adjusted annually. If there's some windfall of money into an association because an expensive amenity was closed, it would be reflected in moving forward. So it would be very unusual. It wouldn't be our recommendation to adjust your budget downward because of an amenity being closed. Andrea, so now we have a potential risk of someone not liking that we closed or opened the common areas too early or too late. What kind of coverage, if any, would we have for that, Andrea?
Right. So it's really going to depend on the different policies because there's no one standard directors and officers policy in the state. But what you're going to be looking at is, you know, Donna did a great job of expressing what the liability may be. Unfortunately, all of our boards have a huge amount of suability, as I like to say. And so while at the end of the day, the judge or the jury may find that they weren't liable, we have to see, is there a policy that's going to pay for the defense, or is the association going to be paying out of pocket? And it really depends on a lot of different policies that are out there. There are actually a number of directors and officers policies that exist that don't provide coverage for what would be referred to as a non-monetary claim. And so if it was strictly related to, you know, starting something or stopping something, there could be an exclusion there. But when you do have coverage, let's presume you've got a directors and officers policy that's worth its weight, that has protection for a non-monetary claim. So you've got the defense. What you're going to be looking at is how the claim is going to be framed. So ideally, it's going to be, you know, you violated an executive order, you violated a local ordinance, you violated our documents and restricted access to something I should have had. rights and access to, it's not likely you're going to have an exclusion in the directors and officers policy that's going to be triggered. If we take the reverse and we say you waited too long to do something, and someone said you board failed to enact rules that tracked with the executive order or with the ordinance in the state, and as a result, a family member was sick and they died, you're going to have a straight exclusion, no defense, no coverage for that bodily injury or for that sickness or their resultant emotional distress or mental anguish. So it's really going to come down to the policies itself. But I think if you err on the side of caution of abiding by what the preset rules are, and you're more likely going to have coverage afforded than if you do the reverse and it ends up in a bodily injury or sickness.
Okay, Donna?
A quick follow-up on that. So we're seeing some counties and municipalities that have now issued ordinances that require face coverings when people go to the store or they go into their office spaces. And we've been talking about this a lot at Becker in terms of whether or not that would be applicable in our multifamily buildings. To me, I don't know how much sense it makes for somebody to leave their unit with their face covering tucked into their pocket or their purse, walk down a narrow hallway, get into a small elevator, and only put it on when they get into Publix. So the question I have, and you just talked about this in terms of policies or lack of policies that don't track the applicable and most current ordinances, do you see that as a problem? Do you think that that could be a potential issue in terms of associations not revising their COVID-19 protocols as these ordinances continue to be modified, including with the face covering?
I think from an exposure response under the policies, it actually doesn't change too much. I would err on the side for liability getting to the end judgment of saying it's a good idea, but if they're going to be the governing authority that's responsible for making sure somebody's wearing their face covering, I don't know how they would have an enforcement mechanism. But from an insurance perspective, it all depends on how the claim is worded. If the wording is, my board failed to enforce face coverings, whether or not they had the authority or the ability to, and it resulted in my sickness, you still have a sickness exclusion under the directors and officers policy. So there's still an exposure there for the board itself. It's kind of a lose-lose for our boards, because if they enforce it and then somebody says, you enforced something you shouldn't have, and it resulted in my emotional distress of having to wear a mask all the time in my building and I'm scared now, versus you did do it and now I contracted something, the exclusions remain the same.
Donna, it looks like you want to say something.
Well, I think that's just a very important point, because we get asked all the time, is it enough just to create the protocol but then not enforce it? Or do we try to enforce it and we're taking steps? I mean, clearly, look, let's take a typical water leak situation. You respond, we want to make sure that we're not subject to negligence. So when we're told there's a water leak, we go out immediately, we investigate it, we respond, but sometimes we can't find the source of the leak immediately. But as long as we're taking steps, that we're responding and we're making our best efforts to find the source of the leak and to repair it, I think we're going to be pretty good in terms of staving off a negligence claim. Here with these protocols, let's say we pass a protocol that say we want you to wear face coverings when you exit your unit. And again, this is really only applicable in a multifamily building, not in a single family detached home, homeowners association. Is that good enough, or is that bad? Because we know we're going to have an enforcement challenge. Now, certainly they could get a demand letter. We could even get emergency injunctive relief if we had to.
Pick up something, Andrew, you said. You were talking about D&O policies, and you said, there's broader forms or more narrow forms. I think this, I'm trying to narrow in on takeaways for our boards today. It sounds to me like, obviously, Donna's not an insurance expert and I'm not an insurance expert, but our insurance agents and companies are experts. Should our boards be going back to their agents and asking for a broader D&O policy? I assume it's more expensive, but would you recommend that?
Absolutely. If I was serving on a board, and when I have, my focus is on the directors and officers policy, even though it's one of the smallest premiums. Our property gets all of our attention, but at the end of the day, where our coverages and our exposures lie can be very minimal. It's very important to sit down and compare, because maybe even the top 3 or 4 directors and officers carriers that are writing policies right now, there's a big difference between what's going to be excluded with some, where some are going to go so far as, One of them say anything related or touching upon property damage versus one that says specifically tangible loss to property. So there's how the claim is going to be handled would be very different between those two. Those that might have humiliation exclusions, invasion of privacy exclusions, wrongful trespass exclusions, if you can get switched over to a policy that has it, I would strongly recommend it. So yes, as a board, I would recommend you A, find out what's in your current policy, B, find out if you can do any better and make steps to do it. Now, if you may hit a hiccup, which is if you already know you've done something wrong and you're under your more narrow policy, the new carrier is not going to let you bring over that circumstance that you're aware of. If you're aware of a fact or circumstance which may already give rise to a claim, the new carrier is going to want to be apprised of that before they're going to put coverage in place. So you might still be restricted to whatever the coverage was at the time the prior issue already happened. But that's not to say, to Donna's point earlier today, if you can fix the mistakes and move forward in a positive direction and get better coverage, absolutely. And then just a quick point back to what we were speaking about, we really address the directors and officers with regards to the face coverings. It's possible, though, we could file a claim under the general liability policy, because if you did implement it, you didn't see somebody who wasn't abiding by it, and yet still somebody was alleging the association was negligent in their enforcement of it and they resulted in that bodily injury. Your general liability policy is there to respond to negligence that was an occurrence, an accident that resulted in bodily injury to somebody. Whereas the reverse is if you don't put one into play and thinking, if you were told to do it and then you didn't do it, then there's an argument to be made by the general liability carrier that your claim is no longer an occurrence. It was not accidental, because at that point becomes expected or intended injury. If you don't limit social gatherings, people will, be exposed to this, and then you don't do it based upon the advice, you're giving more ammunition to your general liability carrier to be able to deny a claim.
So we do have some questions about enforcement that we addressed last week. We're probably not going to get to revisit them today. But do visit that webinar. We have a question, and I think it's pertinent right now. If a lot of liability could potentially result from someone getting infected, allegedly because of a bad compliance with executive orders or local orders or just bad practices, how could anyone ever even prove where the infection came from? This to me seems like a legal quagmire. So Donna, I guess you first and then Andrea. Are we not all off the hook here because no one can prove where it came from?
So I called some of my personal injury friends in the last 2 days, and yes, personal injury attorneys do have friends. And I asked that question. I said, how would you make a claim that somebody living in a multifamily building potentially acquired the infection due to perhaps a lack of closing down one of the common areas? Let's say the fitness room was left open, because some of our boards are not closing down, did not close everything down at the same time. It was kind of phased. And the answer I got was, depending on the amount of the claim, if it was a younger person who was head of household versus an older person, and again, I'm just translating what the personal injury attorney said, depending on the amount of the claim, they may go for it, because they do not have to prove 100% causation happened in the building. They may say that was one potential source of infection. So again, we started at the outset saying that we live in a fairly litigious society. So if you're thinking that it's going to be impossible to prove causation, I guess the answer I'm hearing from my personal injury attorneys I've spoken to is they don't have to prove 100% causation happened at your pool. It could have been multiple infections, multiple sources.
Well, that gets back to the fact that if they sue, you still have to defend. So we're going to talk about that some more, I know. I want to move to a second scenario because we're going to run out of time and not have given our audience enough scenarios. I am an association board, and I'm restricting move-ins and moves-outs and sales and releases. Donna, I'll start with you, and then Andrea will talk about coverage. But what should we be doing about allowing move-ins and move-outs, and maybe just throw on realtor access into that same question?
Good point. Again, it's going to be situational, James, because if you live in a single family homeowners association, you don't have the same risks. I don't see the need. If somebody's coming in and moving out from a single family home, you've got social distancing. That's not an issue as much as living in a multifamily building. And in a multifamily building, depending on your setup, again, you may have a number of service elevators where you could safely allow that. So some communities are continuing to allow move in, move out because they have the infrastructure to do it. They may put limits on the number of movers, the day, the number of hours. They may require the person moving in or moving out to pay for a company to come in and sanitize it at their cost. So there are ways to regulate the move in and move out without a complete ban, but in some communities, it's not feasible. In some of our older communities where they have a population that's almost 80% vulnerable with people with underlying conditions, there may be no safe way to really allow a group of people to be coming in to move people in and out. And that's a conversation to have with legal counsel. And also, of course, loop management in to see how you can safely do that. With regard to realtors, again, another confusing aspect of the governor's order is that residential real estate activity was listed as an essential activity. Now, we don't really know what that means. Most realtors now are doing virtual showings. I don't know of any communities that are allowing open houses in the midst of this pandemic. I do know a few communities that are allowing limited showings, but for the most part, limited showings have even been shut down. So realtors are they're performing their showings virtually. I would also say to any realtors listening out there, I understand that the realtor form has been updated to take into account potential delays in the closing or move-in due to COVID-19. Please make sure you're using updated forms. It's not business as usual. So if you are in the process of entering into a purchase and sale agreement today or anytime in the near future, you need to make sure you have a rider that allows both parties to safely hit pause on the move in and move out or the closing because they may have to.
And Andrea, so I had a deal to sell my condo or home for an exorbitant amount of money, and it failed because my association wouldn't allow any move-ins or move-outs. Do I have coverage for something like that?
Policy specific on this one because there's a lot of variation between the forms, but I think you're going to find that there are some directors and officers forms that say, you know, you made a decision which restricted access to my unit, and you might have a defense only to that, but if it actually resulted in a damage, you may not have any loss that's going to be associated, depending upon how it's pled. And this is really the key. How everything is pled is how the adjuster is going to review. They're going to look at the four corners of the lawsuit itself, compare it to the policy, and if it's pled in a way that says, you know, this damaged my property, or it was a destruction to my property, or it was an economic reduction of value of my property, and that is an exclusion in the directors and officers policy, that's going to be enough for the adjuster to step in and say, I'm sorry, we're going to deny any coverage and defense.
Okay, so Donna, the next one is just, we had so many questions in the first 3 episodes about who do we allow into the building and who don't we. So I don't know that I have to get specific with who we're denying, but let's say we deny someone access. What kind of liability do we potentially have as an association?
It depends on who you deny. So if you're denying somebody's healthcare worker, if you're denying somebody's caretaker, and the person becomes ill or dies as a result of that, you could have significant liability. If you're denying a contractor coming in to do interior unit renovations, and let's say it's not an emergency repair, you're going to probably have less. Again, we're getting back to the economic damages. So if that unit owner is under contract and now it has to pay certain direct expenses of that contractor, that may be something they pursue the association for. But certainly if you don't allow contractors in to do emergency repairs, for instance, a water leak or an appliance failure, now you're looking at a different set of damages. So it really depends on who you're excluding. If you're excluding somebody's social friends because they're bored and they want to have a COVID-19 party in their house because they've got nothing to do, that's one thing. But again, if you're excluding essential caretakers, home health care workers, contractors who are there to make emergency repairs, I think you have a problem excluding those people.
And Andrea, we deny a healthcare worker access, and something happens to one of our residents. Do we have coverage for that?
Very clearly under the directors and officers policy, I'm going to say no, because bodily injury, wrongful death, sickness, all of that is going to have an exclusion. The general liability policy might be more of a question mark depending upon how they allege it. And it could also be whether or not the carrier puts weight on the expected or intended injury, because, in the same way that if I, throw a punch at somebody and it lands, that doesn't really seem sudden and accidental. I had an intended consequence that was going to happen. If I withhold a sick person access to health care, there's an expected or intended consequence that person may become more ill or may pass away. So I think there's definitely a larger exposure with regards to a lack of insurance coverage for that decision.
I think the whole concept, Donna, of damages is important here. I don't let a contractor in and it's in my unit and I don't get my kitchen done on time. It would be hard to really imagine what the damages are for not having your kitchen done on time. So I think I'm trying to frame these for our audience. Not only do I have to think about coverages and practices, but also, what potentially could be the risk. Keeping a healthcare worker out is a big deal. Keeping a contractor in their kitchen isn't. So these all have to factor into the decision-making of each community.
Absolutely. I mean, and this applies to association projects as well, James. If you're doing, we talked about this in a previous episode. If you have a clubhouse where you're using your association employees to do long stall projects like painting, that's one thing, that the risk is away from the units. But if you're undertaking certain projects where association projects where contractors need to go into units, that poses a different set of risks. Again, if it's for emergency repairs, absolutely. There's other life safety issues that have not stopped occurring just because we're in the midst of this pandemic. We still have the potential for fires and floods, and hurricane season's right around the corner. So we do have to balance the life safety risks here.
I do want to talk about hurricanes. Don't let me forget before we close. We have 13 minutes left here. We did have a question though. I want to go back to move-ins and move-outs. I know some of our boards don't want to approve new leases because that would be a new resident, which would be, from somewhere other than here maybe, and introduce a risk. What authority do we have as boards to restrict new leases, Donna?
Well, again, it's going to depend on a couple different things. Under the emergency powers, the board has the right to declare portions of the property off limits to owners, tenants, guests, and other invitees. So arguably a tenant will fit within that category. But you also have to look into whether or not the board has rulemaking authority with regard to unit use in addition to common elements. Boards cannot take a hands-off approach when it comes to pending lease applications. Let's just talk about that. In many sets of documents, it says that once you get that application, if the board does nothing, typically within 30 days, it's deemed to be a de facto approval. So that may happen. You can't just take a hands-off approach and say, we're not going to do anything. We've hit pause on all these applications. You still need to be working through the applications. And if the applicant meets your criteria, then you should be approving that applicant. Now, whether or not you want to have a delayed move-in date depends on a couple things. I have a couple associations that are updating their applications, and on it, they are clearly putting on there that there may be delays to move in due to quarantine and pandemic and other disaster situations. So they may want to update their applications after speaking to council. And again, if you have a uniform lease addendum, as many of our associations do, you may want to update that lease addendum to take into account the current circumstances. One other thing, James, I know we've only got a few minutes left. I think we really have to talk about notification in terms of an infection and the potential liability when associations notify, and particularly if they name names.
Let's talk about notifications next. It actually was our next and probably the last scenario we're going to get to. So I'll let you take it away. There's two parts to this, I think. The liability to an association if they don't communicate, and then the liability potentially to a association if they happen to name the resident that's infected. So Don, I'll let you tee both of those up, and Andrea, let's talk about coverage after that.
Well, I would never recommend that association learn through a credible source that there was an infection in their community and do nothing about it. That is not an option, in my opinion, because there's a foreseeability of risk here. So certainly disclosing of an infection is important, but there's a way to do it. Number one, it needs to be coming from a credible source. The most credible source for an infection or an exposure or a quarantine is self-reporting. The person has picked up the phone, they've called the manager, or they've called the board, and they've said, I've tested positive, or a member of my household has tested positive. That's number one. The way you craft that notification, and I know there's been some media reports on this and there's differing opinions. In my opinion, there is absolutely no benefit, and this is just from a practical standpoint. We're going to get into the legalities in terms of the potential liability, but from a practical standpoint, I believe it's counterproductive to name names, and I'll tell you why. It provides a false sense of security. If you name an infection on a certain floor or in a certain building, when you've got a community with numerous buildings, it may give people on other floors and in other buildings a false sense of security that they're risk-free. And the reality is, if you've got one infection, chances are you've got numerous infections. You've probably got people who are infected and are asymptomatic or have not yet tested positive. So from that standpoint, I say don't name names. If you do name names, some people are getting consent to name names. I'm not sure even that insulates you entirely. If you have a household where one person has been infected, but there are two other adults living in that household, there is still the potential for the other adults to say that they felt some emotional distress, even though the person who was infected may have signed a consent saying you can use my name. Those other people may not have consented, and they may have potential claims because they feel distressed that they are identified as being in this infected household.
Do we have coverage? We either don't notify our community there's a confirmed case, or we name somebody who's infected without their permission. Do we have coverage for this kind of error?
Not likely. So this is kind of like taking a culmination of all the things we've gone over previously and putting them all together. So again, starting with the suability against the liability, you've got suability on both sides. You've got those who could sue you for failure to disclose that you had even a case. You have those who could sue you for failure to disclose who it was, even though the fact you disclosed there was a case there. And then you have the person who was actually disclosed themselves. First being that they either didn't consent and you provided the information to the community entity anyway, or that they consented and maybe they changed their mind. They didn't expect the consequences that came as a result of the notification or the stigmatization that happened. Again, with those general directors and officers policies, if it's somehow wrongful or illegal to release that information, you've got exclusions for that type of activity. But again, you've got that emotional distress or mental anguish is going to be the glaring, overriding exclusion under a directors and officers policy. That's going to be the biggest part. A lot of directors and officers policies, not a lot, I'll say maybe about half that are out there, have invasion of privacy exclusions. So that one would be very clear. Whatever resultant comes about to the person who themselves were named is going to be an exclusion if they're going to claim that mental anguish. And then again, we go back to the general liability policy and say, okay, well, maybe we can pick up the humiliation or the emotional distress or mental anguish under our bodily injury for our general liability. We again get hung up on that potential of expected or intended injury. We know disclosing somebody's name within a community is very likely going to result in emotional distress and mental anguish. I think the best success some of my communities have had was the person themselves disclose the information. It wasn't even the association that did, maybe they drafted their own letter and the association sent it out on their behalf, and it was, signed by all those within the household that were going to be affected. So I think that there's a big exposure here. At best, maybe you have one of those legal defense policies that might pick up defense only, but again, it's defense only. It's not going to cover any sort of loss that might be tied to this.
Okay. Donna, I have a couple of questions coming in related to this notification. The first one is, do HIPAA laws apply on this discussion of notification?
Yeah, so HIPAA does get raised frequently when you're talking about disclosing somebody's medical condition. Typically, associations are not considered covered entities. They're not medical providers, so they're not typically impacted by HIPAA. But that's not to say that they couldn't be under certain circumstances, depending upon how they learned the information. For instance, if it's an employee who has tested positive, the association insures that employee, and they learn that information as a result of a medical report, then yes, HIPAA could apply in that instance. But again, the broader discussion here is, do we notify? And I think we've all agreed here that if there's an infection and you don't notify, there could be significant liability because you have not notified of a foreseeable risk. Yeah, we can liken it almost to security. If you know there's a security issue and you don't share that information and take steps. So notification, yes, but not naming names. I would never be in favor of putting out the name. I really like Andrea's suggestion that the best way to do it is for somebody who has tested positive to put that information out if they want. And I'll tell you why, yes, you should notify, because people have friends and family in the community. So they tell people, even if they don't broadcast it widely, there will be certain people who will know of an infection. I've learned of that in my own community. And if they know and the board doesn't put anything out, the question becomes, why is the board not told anybody that there's an infection in the community?
Donna, we have questions coming in about, I mean, should the association, hire medical advisors? How do we know when an infected person is no longer infected? So if I can bundle those questions into one, what's the responsibility of the association to track or monitor an infected person's situation? Is there an obligation on the association?
Yeah, we don't want associations to acquire potential liability that they don't need to. Okay, they don't need to be acting as medical advisors. They don't need to be acting as pandemic experts. There's an abundance of information out there from the CDC, from the Florida Department of Health that they can access. Sure, and getting back to the emergency powers in our statutes, it says that they can rely upon information and advice from emergency management officials and provide and professional advisors they may hire. I don't think they need to hire their own consultants, James, but I do think that they can, certainly if they've got questions about quarantine situations, they can access that information through CDC and through the Department of Health. But we certainly don't, this is why I was not in favor of thermometers. Some associations were considering using thermometers. Well, that becomes a problem because, again, we get back to that false sense of security. Not everybody who has this infection, this virus, has a fever. So again, if you're using a thermometer, it may be counterproductive because you're letting people in who don't have a fever but are still infectious. And who's using the thermometer? Are they using it consistently? Are they using it correctly? So I would urge associations not to acquire additional liability that they don't have to.
Yeah, I think that's a good point. And, I'm getting several questions here that are really medical in nature. One of the thoughts I had when we started these seminars is there's enough people on the medicine side talking to the world, we wouldn't get involved. Although if there's enough demand, maybe we'll bring in someone from the Department of Health or something for some more guidance. Okay, first of all, running out of time. Secondly, to our listeners, I think I'm gonna run a little bit over because there's a couple more things I wanna address. We're coming into hurricane season. And so we're going to hand off, hopefully, coronavirus season to hurricane season, and more likely they're going to overlap. Andrea, we have, that's something we usually do focus on insurance for is the hurricanes. And I'd like you to just generally comment on what the pending hurricane season means to us and what we should be looking out for. And then you also told me yesterday the market has gone crazy on premiums, and I hate to be the bearer of bad news to our associations, but I'd rather it be you than me, Andrea. Tell us some of the increases you're seeing, especially for the high-rise communities.
Absolutely. So we're seeing a mix of everything from the different carriers. Whereas a year ago, if we were seeing 10%, that might have been the average, and 15 towards the end of the year, and then 20%. And now we're seeing those coming in at 50 and 60% increases from some of the carriers. They're taking automatic deductible changes. If you were at a 2% hurricane deductible, they're only giving you a 3%. If you were at 3%, you might only be getting a 5% option now. So we're hitting a perfect storm of issues where hurricanes meet pandemics. And you're going to see this, hopefully, to James's point earlier, you guys have done phenomenally well in keeping your April dues on track. But if we get 3 months down the road into the Julys and the economic situation hasn't turned around, if people aren't paying their dues and we've budgeted for a 20% increase and we get a 50% increase on the property, that can be catastrophic. If we've budgeted for a 2% hurricane deductible and now you have to operate under a 5% hurricane deductible, that's something you need to take into consideration. As an aside, as a preparation, my recommendation is whatever funding you need to get put into place, a line of credit, something to draw upon, that it's beneficial to do it now while maybe your financial circumstances still look really good, and that you still have a bank who's willing to lend money so that you'll be able to take care of those when it happens. Because I can guarantee if we have a bad hurricane season, getting adjusters into these buildings to adjust the damage is going to be its own challenge if we're still operating under stay-at-home orders, or people are still needing to social distance. Even though it's a priority, one, you're going to have to find people willing to come to hot spots if we're still in a hot spot, who are going to be able to get access to units. And I'm sure we'll have some fight from unit owners where they don't want adjusters coming into their units. And then just the availability of the construction replacement material to get somebody in there and the workers to repair. So it's going to be a much longer process in the event that there is a claim. Much more difficult circumstances obtaining the coverage as far as rate is concerned, and just being financially prepared for what's coming.
Well, I'm going to try and bundle that. That's fantastic advice. I'm not happy about the 50% increase, but I think that the point here is a couple of them. There's some questions coming in about what about emergency or life safety type of repairs in your community? Absolutely, they have to get done. And in fact, they got to get done before hurricane season. So you have to ask your own counsel, but I think the answer is going to be yes, you need to do that. And the other one that was interesting there, Andrea, is that even if we have insurance, we may have a higher deductible, which means we may need more cash. And if we don't get an adjuster, we may have to be doing repairs without any insurance proceeds because of the length of time it takes to get that money, which is another need for cash. So I'm combining those all in. It gets back to last week's discussion about association finances. What is our operating cash? Stick to our collection policies. What is our reserve cash? Do we have a line of credit? And should we get a bigger line of credit in anticipation of some of the things that you have talked about? And then, as Donna advised us last week, possibly draw that down. There is some concern if we all have these lines of credit and all of a sudden we get a big storm in the middle of July, can we access all of them? So with that, I'm gonna give each of you guys kind of a chance for the final word. And then I just made a little note as we're going along. I have about 10 things written down here that if I were a listener, if I were a board member, I'd say, these are the 10 take homes that I heard today, and I want to recap them for our audience. But Donna, any final thoughts on risk mitigation for our boards before we close?
Yeah, and first of all, let me say, let's hope we're not in the midst of an evacuation order for hurricanes at the same time we're in the midst of a stay-at-home order for the pandemic. So hopefully that's not what's going to happen. One will wrap up before the other comes into play. In terms of risk management, again, boards are not held to a standard of perfection. You're expected to exercise due care. You're expected to exercise the judgment that a reasonable businessman or businesswoman would exercise, and you have access to advisors like Castle Management, your legal team, to craft the reasonable protocols. I would urge boards, anybody listening, that this is not the time to be implementing protocols without the advice of your counsel and without the advice of your management company. This is not the time to go it alone, because as Andrea said, and as James said, and as we're talking about, we're looking at risk management here. So if you're going to be second guessed, you're going to be second guessed in terms of how did you reach these protocols? By the way, under the business judgment rule, if you rely on the advice of counsel in crafting those rules, you're going to be protected for the protocols that you implement. And I hope that is a huge takeaway here. If you've done it on your own, you don't have that protection. So crafting your protocols, exercise due care. It's not too late if you haven't done those steps right now. By the way, if you took these steps and you didn't take them at a board meeting, you need to ratify that, because I know some boards out there may just have made these decisions and broadcast them and not really had a board meeting. So you'll need to ratify the steps you've taken, and you need to revisit the protocols. If we've learned anything, we're on episode 4 now, James. If we've learned anything, this pandemic continues to bring new challenges every week. So I would urge you, these are not protocols that are set in stone. What you did 3 weeks ago may need to be revised today, may need to be revised next week, and as in the coming weeks. And also, I'm sure we'll talk about this in a future episode. It's going to be very important to use due care when opening things back up, because that's going to be another area where there's potential liability.
Okay, and Andrea, any closing thoughts?
Absolutely. I would say first and foremost, if you ask any of the carriers out there what their position is on any of these, the official position of those that you should take with you is, we're not making any coverage decisions. It will be a claim by claim basis as they come in. So don't take this as set in stone. For me, knowledge is power. So it's a great time to go ahead and get a hold of your policies and read through them and at least understand where you see the exclusions and where you don't see the exclusions, to learn where your gaps are, so that if you are making a decision and you have to weigh out between the two and you're going to take one that's going to potentially prevent you from having bodily injury or sickness or death claims, and you've got an exclusion for that, and that's a safe decision, that might be the route to go so that you might have some defense in the future. And just see what you can to fill in the gaps, and where you can't, just be aware and be prepared.
Thank you, Andrea. So let me try and summarize, ladies. Number one, there is a business judgment rule that applies to our boards. And as long as we're taking due care and making sound judgments and getting appropriate advice, that's kind of the first step in risk mitigation. Two, for the comfort of our board members, there is an indemnification provision in most of your documents to shield you from personal liability. And that's very important to me because I need you. We need you to run your communities. We need board members, and we are so grateful for your leadership. Three, there is it's relatively new, a coverage called legal defense, a coverage that is a possible exploration. I really think the biggest takeaway from the insurance side, Andrea, is we should all be reviewing our policies with our insurance agent and making sure that we have the appropriate policies and take a second look, have a look at the exclusions. We talked about what is a standard at which our decision should be supported by, and Donna made a good point that the executive orders of all of the various levels of government should at a minimum be honored, and possibly further if that's relevant to your community. But it's really the floor, not the ceiling, but we should be following those. I also wrote down, I'm going to just jump back up a bit, on your D&O policy, there are differences in the broadness of the coverage. And sometimes we have communities that want to keep the dollars the smallest and they have the most narrow coverage. And maybe it's time to relook at that. There is the whole concept of foreseeability of risk. And I think it's one we should all think about as we try and make decisions in our communities. Is this something that we could have foreseen or not? And have the appropriate best practice around that. And one of those would be notifications. And I think what I'm hearing from you ladies is notify, but don't name names. And then we jumped into the hurricane season, which is coming up soon. And just the thought of these seasons overlapping puts a new dynamic on it. And anything that has to be done that requires a contractor to come in, which generally we would advise against, get them in and get any life safety or hurricane preparation done, or we're going to have a bigger problem down the road. And then obviously there could be some extenuating cash requirements for our community. So let's make sure we take the appropriate steps now to make sure we have the resources we need in the case of a hurricane or other situation. And then finally, listen to your advisors, get advice. It's not only a great risk mitigation practice. If it's your management company or your lawyer, or your accountant, or your insurance agent, this is what they do all day. And so do go and get all of that advice and synthesize all that into an appropriate decision. So Andrea, special guest today. Thank you. Donna, you're always a rock star. Thanks for being back. And this is James Donnelly saying to all our listeners, we're going to be back next week. You are going to get a survey like you do. And it's so helpful for us shaping the topic for next week. We haven't decided. Last week we knew ahead of time we're gonna do this, but there's so many different things. And even today I can see questions I was not able to answer. So please send it. And we're gonna keep doing these until people stop listening to us. But with that, please stay healthy. And we look forward to talking to you next week. Thanks, everybody.
Thank you all.
Thanks.
Stay well.